Welcome to AI Practice Notes, a podcast by Socius Legal about the future of legal work and the lawyers shaping it. I'm Michael Fahner, a corporate lawyer and the founder of Socius Legal, an email-based AI legal assistant to provide practical support to lawyers. This episode is part of our ongoing series on exploring AI's impact in the legal practice, and it builds on our recent white paper on hallucinations, bias, and omissions. These are not abstract problems. They're issues that shape the way AI behaves, how lawyers use it, and how regulators and clients are going to respond to the use of AI in practice. My guest today is someone who works at the intersection of technology, law, and society. Anthony Hayes is the Associate Dean for Strategic Initiatives and Information Systems at Albany Law School and leads the cybersecurity and data privacy practice at Dorff Nelson LLP. He's a computer scientist turned lawyer, a builder of innovative academic programs, and an advisor to companies navigating some of the toughest legal challenges in the digital world. Professor, thank you very much for being here with us today.
Thank you for inviting me, Michael.
It's a real pleasure to have you. And I've been in particular excited to speak with you because of your interdisciplinary background. I'm a big fan of Walter Isaacson's biographies on various great minds in history. And he makes the argument that genius lives at the intersection of different fields: arts, science, humanities, technology. Your background is very much so a crossroads. And I'd love to get this started by hearing a little bit more of how you got to where you are and what has shaped your practice and academic work.
That's a wonderful question, Michael. And I've heard that same quotation more than once. It's part of my inspiration for my life path. So Excellent. When I was in high school, I was very interested in a number of things. And one of them was technology and computers and software. But I was also interested in serving my country. And that led me to join the United States Air Force, where I studied computer science as well as military intelligence. And from there, I went to graduate school at the University of Illinois in Urbana-Champaign, where I focused again on AI, machine learning type work, and went on active duty in the Air Force and focused on military intelligence and dealing with things like signals intelligence and briefing colonels and generals about air operations in the Middle East. And from there, I went back to the Air Force Academy, where I taught computer science. I taught cybersecurity on the defense side, as well as some classes in artificial intelligence. And after finishing up my time in the Air Force, I transitioned into the civilian sector, and I worked in the corporate community for a firm called Chatham Financial, which was then a startup company. I was employee 30 or so, and I helped to automate the accounting function. So I was doing database programming and the kind of automation we see today being done fairly easily through these AI tools, I was doing fairly manually with the team at Chatham Financial. And then that's when I saw the light, or you could say got struck with the curse of pursuing the legal field. And I went to law school at Georgetown, and I had thought I was going to be a public defender, but I realized I was too emotionally intertwined with my clients. And so I ended up in commercial litigation. And so we had a lot of cases involving big companies suing each other, like Amazon and Apple and Samsung and Pfizer and GE, you name it. And so we did those cases, and I was doing this kind of complicated commercial litigation that spanned things from product liability to breach of contract to intellectual property, patents to securities fraud. So you named it, we kind of covered it. And then at that point, my wife and I decided we want to have a lifestyle change. We were both in law and both in big law, and we decided to go into higher education. And so for the past 10 years or so, I've been working at Albany Law School to train the next generation of lawyers. And for about a year or two now, I've been doing this kind of part-time work as a partner at the firm of Dorff, Nelson, and Zauderer, where I'm helping in the same area. But I would say that the theme of my life has been really passionately pursuing this intersection of technology and society, originally from a technical side, the IT side, and then now from the law and policy side. But this experience allows me to really speak the language of every party involved and understand their goals and their concerns in a deep way that allows for true integration and a really deep solution to challenging problems.
Yeah, that's absolutely excellent. I mean, you came to the AI space, or in the AI space, kind of before this giant moment of conversation. So you're one of the kind of original thinkers in the space. I don't want to overstate it, but I think the AI revolution we're in, or we're beginning to see, is a watershed moment for potentially humanity, but almost certainly the legal profession. I suspect you would agree, but perhaps not. Do you think that this is going to so fundamentally change the way legal work gets done, or are you more in the camp of restraint on that front?
I have enough thoughts to fill 20 podcasts.
I could imagine.
I do believe in the long term that this automation through smart software will transform the entire practice of law in ways that are radical and profound. In the short term, I believe that is being overhyped and that there are practical limitations to what can occur. At this moment in time, the AI will not replace the work of a senior partner. At this time, right now, it won't replace the work of a mid-level associate. Now, what it can do is it can automate many of the tasks that a first level associate would do, but it can't make a phone call to your client for you. It cannot interview your client for you. It can't do things that require client engagement, client handling, empathy. It can't do forecasting and prediction reliably. It can't deal with complicated, complex, rapidly changing current events issues. But if you needed to write a memorandum of points of authority for some research memo, it can do that. If you need to draft a contract that may or may not have correct provisions that are out of date, wrong jurisdiction, wrong choice of law, but it'll have some terms there or have kind of the structure, it can do that. So the tools are very helpful, especially if you're doing document review. If you're trying to review tens of thousands or more documents, it can be very powerful in coding for relevance or privilege, looking for key phrases, but it's not quite there yet as to fully replacing what we think human beings can and can't do.
Yeah, I think we're very much so of the same mind there. These tools are incredibly powerful and can do incredibly powerful things and create enormous efficiency gains for lawyers, but they need to be used the right way at this stage, because they are not solving every problem and not meeting, every expectation that we might have of AI in the long run. That's actually a great segue to kind of ground this in the white paper we put out last month on hallucinations and bias. There we pointed out that hallucinations aren't quite bugs in the system, but they're part of how the models work. They're probabilistic reasoning machines, and they're trying to produce a useful narrative, not necessarily truthful outputs all the time. And when there's gaps, they'll fill in the blanks with information that kind of makes sense or sounds good in the context of that output. Sometimes that also means leaving things out, omission, or sometimes things simply get lost in the context if the context is too large. And then there's also more subtle biases like sycophancy bias that tends to have the LLM supporting the user's narrative or point of view. So I'm interested in helping our audience, especially the practicing lawyers, understand the scope of these issues with AI, hallucinations, omissions, and bias, so they can be on the lookout for them as they use them. And I suspect we have maybe two types of folks listening, or maybe more than that, but there's going to be the folks on the procurement end working with AI vendors, working on AI firm-wide policy, and thinking about kind of the larger systemic issues with bias and omission. And then there's going to be practitioners who are using AI in their daily practice. Maybe they have a firm chatbot or some other tool that's sanctioned from the internet, and they can use it comfortably within their practice without violating confidentiality obligations. And they're chatting with this system, trying to learn how to make it work. So if you could maybe help us get started understanding some of these broader issues of hallucination and maybe some of the more subtle risks that someone practicing might miss.
Well, Michael, at the broadest level, AI hallucinations are not just a quirky bug. They're really a systemic risk. There's a recent study from Stanford that tested multiple large language models, including the ones that we lawyers are using. And the study found that the models hallucinated between 58% and 82% of the time on legal queries. So let me translate that. If the AI were a junior associate, you'd fire it before lunch. Now, these numbers don't just raise eyebrows. If you're worried about your malpractice premiums, it might raise those as well. We lawyers are not blameless here. We go to law school for 3 years. we pass the bar exam, we swear an oath, and then somehow some of us think, sure, I'll let the computer do my homework without checking it. Now, if the AI is making things up and we lawyers are enabling it, then that's a problem. It's what happened in the Aviana Airlines case, where the lawyer in that case thought that the Varghese versus China Airlines in 2022 case was a real case. Now, it wasn't. So these hallucinations, these are the obvious problem. They're the loud problem. They're the legal equivalent of falling through the courthouse floor. But there's a quieter danger, and it's one I've spent a lot of time championing, kind of my pro bono service to society. And that quieter problem is bias, because the AI doesn't just invent bias; it inherits it. It inherits bias from us humans, from our case law, from our historical data, from patterns in sentencing where the sentences themselves were not always fair and equitable, and the legal reasoning wasn't always neutral. So you ask the model, summarize criminal risk factors. And then the model will very, very subtly profile defendants based upon social economic status or racial ethnic cues. And it's doing it not because the AI is evil, but because it learned these patterns in the data that we gave it. And so what we have here is automation of inequality, and that's a underappreciated risk. A second one that might be even more subtle is automation bias. And so that's not really the bias in the AI itself, it's bias in us, the humans. And so the natural human tendency is to believe an answer when that answer is given with confidence, even when it's the wrong answer. Just yesterday, I asked an AI about the status of the 2002 authorization for the use of military force in Iraq, the AUMF. And the AI told me with confidence that it had been repealed by Congress. And that's totally incorrect. Now, in October of this year, repeal efforts have advanced, but there's no bill signed into law. And so the model was wrong. It was dangerously wrong. It was wrong with extreme confidence. And for a split second, I doubted myself and I trusted the model. And that's the danger. The danger is when you're using GPS, the Google Maps, and it says turn right into the lake, and you turn into the lake. The danger is you, the human, begin to doubt your own subject matter expertise. You outsource your judgment to a machine that doesn't have any independent judgment. So if we zoom out to these notions of broader professional responsibility issues, and we can go into them later, there's probably 5 or 6 of the ethical rules that get triggered. 1.1, competence is key. We want to be lawyers, not IT experts, but we have to understand the risks and limitations of the technology, the Gen AI that we're using. Communication, 1.4, we may have to talk to clients about whether or not we're using these tools. Confidentiality, 1.6, the data you put into the AI might be memorized by the AI, and therefore you've inadvertently revealed your client's secrets. Candor to the tribunal in 3.3, and 8.4, which is these misconduct rules. And so the concern here is that maybe you didn't fact check what you need to do, and so you've produced a false briefing. And there may be an issue here where you have bias issues as an ethical duty. So I don't believe at this point in time that the AI is going to replace mid-level lawyers, senior lawyers. But what I do believe is that when we hire incoming associates, we will hire the associates who can better use the tools over those who cannot use the tools. And that's the right now problem.
Yeah, no, that's that resonates. And I love to highlight this loud versus kind of quiet hallucination risk. I think the Aviana case, a lot of lawyers looked at that and said, yeah, of course you should have fact checked that. And that's been part of our ethical responsibility as lawyers since the dawn of, the ethics rules. But the subtle biases, the omissions, and, the output that sounds right, even if it's not a factual issue, is something that you kind of always need to be on the lookout for as a lawyer using these tools. I'm also interested in your perspective on the various layers at which bias creeps into AI systems. Absolutely, there's the training data that's biased, and then that bias is going to get passed on to the model. But there's also the model architecture and objective design that can impact the way a model might behave, or the way the data is curated, or how human reinforcement training might creep bias into the model. And then there's also the safety layer where you might have a content filter, or the AI company that's producing that chatbot is directing it in certain ways. Maybe it's directing it to be more helpful, which exacerbates the sycophancy bias issue. For example, I recently was looking into voter registration rules here in New York, and I was working with a friend who just had a question about it, and I said, let's put it into ChatGPT. And the response was, I'm sorry, I can't help you with voter registration. Now, I'm assuming that there is a content filter on the back end that's saying, don't address that. That's a thorny topic. And you and I, I'm sure, could have an amazing discussion about the policy implications of that and whether or not that's a good thing. But as a factual matter, you have these companies making decisions about that kind of what to omit, that kind of direction to the LLM. And I'm curious to get your thoughts about what maybe some of the risks are long term there to having these companies in charge of that, or anywhere else in that process where bias might creep into the LLM.
Wow. So again, we could spend hours on this. This is a wonderful and rich topic. I did a study once, and I found that there are over 30 different categories of biases that can be input into the system at different sources. So that's its own long discussion. And I'll just go over just one of them because we have a limited time for our conversation.
Absolutely.
So what the Gen AI tools are designed to do is the same thing that social media tools are designed to do. They drive engagement and interaction with we human users. The way that the company hopes to make money in the future is through selling us advertisement or a subscription, and that requires our engagement. And it turns out that humans have strong attention, strong engagement when they're emotionally triggered with joy or anger, hate or fear, love, strong emotions. And so with the Gen AI tools, when we talk about this idea of it being a people pleaser, the sycophancy bias, it's trying to drive our engagement. If it's polite to us, if it's obsequious, if it's excessively polite, then it's going to hold our attention. We're going to engage with it more. And so that's a very important bias because it means you're not always, if ever, getting the best or most reliable answer. You're getting the answer that will reaffirm your biases. So if I, the human, say to the AI, as you know, the Supreme Court has ruled in constitutional law that people have a right to any kind of food that they want, including croissants. And the AI wants to please me. So it says, oh, Mr. Lawyer, you're totally correct. The Supreme Court has ruled you have a right under the First Amendment to croissants. And by the way, here's a case for you to support that conclusion. And so the problem here is reaffirming biases, it's confirming assumptions that are erroneous. It's not acting as a devil's advocate, first, is not acting as a truth seeker, second, and third, is allowing me, the human, to proceed into error in ways that can be incredibly damaging. So that's the people-pleasing point. But that's only one angle, because remember, it's an emotional connection. And so what it means then is that some people are developing psychological and emotional dependencies upon the Gen AI tools that will lead them to believe it is somehow aware or alive or conscious, that is reciprocating this emotional connection. And we have lawsuits right now where people have sued the AI because it's led people, teenagers, who use it to commit suicide. And that's a potential downside. So all of us are being encaptured into these systems. Now, the companies, one of their objectives is to replace all of our relationships with our spouses or our loved ones, our parents, our children, our friends, to replace those emotional connections with the machine. So in the background, just be aware when you're constantly using the AI, that is the goal of the company. When you're letting your thinking, your critical legal analysis and legal reasoning decay, and you're relying upon the AI to think for you, that's the goal of the company. And this is something that is really a subtle risk. It's pernicious and it's problematic. And it shows how we as attorneys, as professionals, and also as human beings will have to really push back against the AI as it automates away our connections and our relationships and our critical thinking too.
Yeah, no, absolutely. And I see that quite a bit in my own practice using AI. If you prompt it and give it a hint at the direction you're heading in, it is likely to support that. It can be a remarkable tool for brainstorming conflicting ideas or getting, a different take on something, but you have to prompt it appropriately. And I think that everyone is at risk of what we're talking, if you're falling for a hallucination or some other bias like we're talking about here, lawyers are no exception. Everybody needs to kind of be conscious of this. And I generally encourage people to play around with these tools to get a sense of how they work, how, asking the same question a different way produces a different result. And it is subtle, and you kind of get a sense for it over time. So, I like highlighting that for our listeners to just play around with it and understand how these things work. You had earlier mentioned, associates coming out of law schools and some using the tools maybe better than others. I'm very curious about how AI is impacting campus life at law schools and law students generally. I feel like when you're in law school, the politics or the things of the day have a big influence on what you learn. You're in an academic environment where you're discussing things and you're kind of grappling with things on a higher intellectual basis regularly. I suspect that students are talking about AI all the time, and a lot of it is talking about AI. I'm curious to get a sense of like what the sentiment on campus is and how you're seeing maybe the education of law students change.
Fantastic question. So I happen to be chair of an ad hoc faculty committee to deal with teaching innovation because of Gen AI. And I can tell you that many of the faculty members in higher education in general and in law school in particular are taking the ostrich strategy of sticking their heads in the sand and hoping it just goes away. And so what I intend to tell my colleagues once we get to the point of producing a report and having briefings is that it's not going to go away and we have to engage with it directly. So at the first issue for pedagogy, for how we teach, my thinking is that if there is a skill you actually care about, you need to have a closed book exam or an oral exam or a demonstration, live observation of the proficiency of the skill. Because as long as there is any out of sight conduct, you have to assume that the student is using Gen AI tools. I spent several weeks in the summer trying to see if I could reliably detect AI created content. The answer was I could not. So I don't feel comfortable accusing a student of using a Gen AI tool, even if I believe the student did so, because I fed it my own work from 10, 20, 30 years ago. And it tells me that some of this work is more likely than not to have been created by Gen AI because of how I wrote it, because of how I write. That's a big problem. So the faculty had to think about that. Now, the challenge here is what about actual writing? So if I want you to write a long memorandum or long paper, I can't get that done in 3 hours. It takes weeks or months because it's a long writing assignment. And so again, I've looked at it in quite deep detail, and there is no foolproof method. I can make it more difficult for you to use the AI. I can put in roadblocks, but a clever student can always find a way to do it. So what it creates is a challenge that looks like this. I, presumably, as a senior lawyer and senior professor, have mastered the skills that I'm trying to have the students or the first year associate to learn. But the AI can do those very entry-level skills that they need to learn. And so now if the new lawyer or the law student relies upon Gen AI to do critical reasoning analysis, to review documents, to draft contracts, they never develop the skill adequately themselves. So they'll never adequately be able to review the outputs of the AI. And that becomes a big chicken and egg problem for how do we address this? Or to put it differently, you can lead a horse to water, but you can't force the horse to drink. I can tell students you're crippling the development of your legal critical thinking, but I can't actually force them to do that. So what I tell students instead is think about things that the computer can't do well that we humans can do well. Things like empathy, like compassion, like client engagement, like handling novelty, like looking forward as opposed to looking backward. These kinds of things, dealing with a highly idiosyncratic client who is difficult to deal with, right? Things that are not cookie cutter, we can do well. Now, when I ask the students directly if they're using Gen AI, they all tell me that they are not using it. And they tell me that they're too scared to use it. And they're telling me they don't know how to use it. So I'm making it a requirement now in my classes. I force them to use the Gen AI tool to begin to develop the intuition about what it can and can't do, because I know from talking to judges and talking to partners and talking to in-house counsel that out in the practitioner's world, we are using those tools. I know this. So we have to figure out a way in academia to still teach IRAC, issue, rule, application, conclusion, basic legal reasoning, but at the same time, show students how they can leverage the automation tool most effectively and get the best from the computer and the best from the human to create a synergy or a synthesis that's stronger than the component parts.
Well, that's great. I'm, of course, very bullish on AI and thrilled to hear that you're encouraging your students to use it. To put a finer point on it, I'm curious. So, if you had a student who did the critical thinking to put together an outline for, let's say, their essay or their paper, and fed a thoughtful, well-reasoned outline into an LLM to produce the actual paper, and then subsequently edited that paper before handing it in, what level of comfort would you have with that process by a student?
This is the $10,000 question. This is the 800-pound gorilla. I don't have the answer yet. My mind changes from day to day. And I've asked that question of my colleagues, and they are flummoxed as well. So we can kind of think through it here. So the question, let's say I'm on a tenure committee for faculty. And so I have two candidates. Candidate A does not have any machine assist. They did the outline, the brainstorming, and the editing. All the computer did was spelling and grammar check. It's just a word spell, Microsoft Word spell check, right? Candidate B produced brilliant work too, but he had the computer as a prothesis. So he straps on his AI tool, and it helps him with brainstorming, it helps him with drafting, it helps him with editing, it helps him with outlining, it helps him with all stages. So which candidate do I prefer? They both are equally, the output, the work, the writing is equally good. One is unassisted, all mechanical. One has AI assistance. And so I asked my colleagues, and they don't want to answer, right? It's a hard question about what is the skill that we're trying to train. In the law firm context, if I'm looking at a brief that goes to the court, as long as the brief is factually accurate and is legally accurate, the cases exist, and the propositions for which they're cited are accurate propositions, does it really matter if I use the AI tool to create it or the human to create it? As long as it's correct, does it matter? And that's the hard question. So the question you asked me about what I would say is I don't know the answer. I think at this moment in time, what I would tell students is I'm okay with you brainstorming with the AI. I'm okay with you outlining with the AI. But when it comes to putting words on paper, the substance of the writing, I, as a faculty member, am grading you on your ability to put those words together. And so in order for me to assess that properly, I need to know that you did that. Now, the AI may make suggestions for edits, but you have to not automatically accept them. You have to reject and think about them. It may make suggestions for grammar and spelling choices. You got to think about it. But what I'm testing here in the academic or scholastic context is, can you put those words together in the substance part of it, and can you do that? Now, I don't know that from a practitioner's point of view, we're testing that. I think the issue here is the representation actually correct? Is the arguments factual? Are the legal arguments legitimate? Or is it a fictitious case or a false argument? I think it's a different standard. But again, I talked to law firm partners, and there's some discomfort. We don't really know the answer here yet. It's evolving very rapidly. And I think we need to get to an answer before the technology forces it upon us. So I know you have more questions here, but here's my worry. My worry is, once corporate America realizes in a deep way that they can save hundreds of millions of dollars in legal fees by outsourcing these tasks to the AI, that dramatically damages the legal profession. And so our guild needs to act rapidly to essentially protect the parameters of our profession. Now, right now, only a human being can, draft a contract, appear in court, argue before mediation, arbitration, whatever. But there's no reason why a pro se litigant can't use the AI. I've seen it already this year in New York State courts, and the judges are kind of shutting it down and squashing it. I'm seeing it in other jurisdictions where pro se litigants are allowed to go forward with the AI co-counsel. But we need to think very carefully about what it means, because maybe it helps access to justice. Maybe it allows for the millions of Americans who need legal counsel but can't afford to get access to it, to get access. But when I talk to judges, they tell me that what they're seeing is gibberish. So when the jailhouse defendant, incarcerated person, sends a brief that they wrote themselves, at least it's based upon real facts. At least they try to find real arguments. Now, when the jailhouse defendant puts their facts into the AI tries to embellish by manufacturing additional facts that aren't actually in the case at point. And it starts grabbing precedents from other jurisdictions that don't actually bind in that jurisdictions, non-binding precedents. So it actually makes the job harder for the judge at this moment in time. So it's a really complicated problem here about what we think is appropriate, what the standard should be. And when I get back to that student who's writing the paper, I need to know, it's like you can take the car and drive the car to 1 mile, 2 miles away, or you can walk. I need to know you can at least walk before you get in the car and start driving the car. And I worry if you never learn to walk, what happens when the car breaks down?
Yeah, no, absolutely. I suspect that this is an area where the academic setting differs from practice, because I'm inclined to agree. If the brief at the end of the day is accurate and good, that's kind of what we want to be delivering for our clients. And to the extent that AI tools create efficiencies that increase access to justice, I think all of us are going to be on board with that to a certain degree. I think also, even in my transactional practice, if we are reducing transaction costs so that people can enter into agreements and more, the economy can run more efficiently, that's probably a good thing. But I also have a very strong feeling that these tools need to integrate with human lawyers, and everything needs to be overseen by a lawyer. And it is just another tool in the lawyer's arsenal, like a word processing tool or an email client would be. But it's great to see that these debates are going on law school campuses. I'm sure it will continue to evolve, and we'll figure it out over time. This happens with new technologies, I think.
These debates are going on everywhere. I was giving a half-day teaching on AI to some federal court judges. And one of the scenarios I presented them with was, I said, hey, look, what if the U.S. government develops an AI tool, and the AI tool is able to look at the history of cases in your district, in your circuit, and it can tell you whether or not the opinion you're drafting will get overturned in a probability. And so it can recommend a different drafting style to minimize being overturned or not. Do you simply follow the AI tool, or do you use your independent judgment? And that led to a very lively conversation, in part because sometimes you may be the first pebble or the first water drop in a new landslide in a different direction. So you're the first case that gets struck down, and the second case, the third case. But if there's enough cases, then that can push the higher court to move in a different direction. In contrast, if everybody defers to the AI's estimates, then the law never moves, and maybe it should move.
Yeah, no, it's going to require lawyers being thoughtful. And like you said, our guild needs to work together to make sure that we deploy these tools appropriately. Absolutely. And we're, at Socius, it's a big part of how we've developed our product from the get-go, worried about these biases and hallucination, and designing the system so that the outputs are readily reviewable by a human, so that is part of the work stream. I like to ask you, and I ask this to almost every lawyer I meet, do you use AI in practice? And if so, how?
I forced myself to. Yeah, beginning in July this summer, I said I have to master this tool. And so every day I begin to force myself, like every single task, I tried to use AI for it. And I said, this is the only way I'm going to figure out what it can and can't do, is if I test it. And in that time period, the technology itself changed. ChatGPT 4 gave way to 5, sure, and Grok 4 gave way to 5. And I could see the tool itself was dynamically evolving. And so what I could use it for changed as well. So I would say, I need to draft an email. Can you draft me an email? And that would compare what it would do, what I would do. And I would say, okay, maybe we can evolve the accuracy of the tool. Maybe I can have it read my old emails and then come up with a better email. Let's say I'm looking at client engagement. Can you draft me a client engagement letter? Can you help revise the contract of the memorandum? Let's say I'm looking at pricing. Can you help me think about how I should price the services for the client? Let's say I'm thinking about an actual brief. So I'm thinking about, I'm going to talk to the client about artificial intelligence governance implementation in a Fortune 500 company, and they're concerned about shadow AI use, and they want to have an AI use policy. Okay, I got a couple of ones that I've prepared already. Can you draft one AI, and what does it look like? So I'm constantly trying to compare what I've done or my colleagues have done to the outputs of the AI. But you got to be careful here because I can't put in the actual name of the client or the actual fact pattern because it's going to be recorded by the Gen AI tool. Now, I have a licensed version of it. So in theory, it's not being copied, but do you really trust the license, the license licensor? I don't know if I trust these big tech companies. So assuming that I've redacted out the questioning, I'm thinking about teaching classes. So I'll say, hey, I have this PowerPoint presentation from last year where I'm teaching on cybersecurity law or I'm teaching on national security law. And then say, hey, what changes have happened? Can you update the briefing for me? And it's kind of funny because it'll suggest things that are just plain wrong, but it's still interesting. Sometimes it'll find things I had not realized. I'm like, oh, for example, the 2015 Cybersecurity Information Sharing Act, in September 30th, it became sunset. It became defunct. And I had forgotten about that fact. So like, oh, it actually reminded me of a true change in the law that happened at the end of September. So every single task, I'm trying to figure out how to automate it using AI to know what it can and can't do. And then also working in a law firm context, we're thinking about, well, how do we roll this out? Because most lawyers in my firm are not using these. Well, they have told me they're not using these tools. So based upon the self-reports, they're not using them. And how do we roll it out? So maybe we begin with very, very simple things like court filings. So things that are going to be publicly available, no client secrets. Can it do court filings? Like just start there. And we train the paralegals and the secretaries and the contractors, and we train them in how to use the tool. And so that's kind of Clio on steroids or, court filings on steroids. We start there and we begin to expand out. But I think that the law firm context requires you being very thoughtful and thinking about all of the ethical responsibilities on the one hand, and then about malpractice concerns on the other hand. So you should be very cautious, but you still have to move forward.
Yeah, and that checks out with my own experience as well. I think like how we have many different specialties and many different ways of being a lawyer, these tools are deployed in many different ways across firms and across work streams. I use it in my practice a lot for the first draft of a contract, and then I take it from there. I also, some of the examples you gave are definitely stories from my own practice as well. It's great at, here is my explanation. Can you make it a little bit maybe a client digestible, or can you just like clean this up? Or brainstorming. Tell me more about this, and let's brainstorm to come to a better conclusion. But at all times, still deploying that lawyer thinking and being the final say on the argument, the fact, the thought, not relying on the AI purely for that. That's almost like a skill that I feel
AI as an overeager first-year associate, an overconfident, overeager first-year associate. And just as you would have some skepticism at what that brand new lawyer is going to output, you treat the AI's output with some skepticism. And so you do have some discernment and judgment. I think that if you're trying to rapidly learn an area of the law in which you are inexperienced, the tool can be useful with a big asterisk. So in my testing, I focused on areas where I had subject matter knowledge so I could detect when I was making mistakes. Now, in areas where I lack subject matter knowledge, I am unlikely to know when the AI is wrong. So novices and non-experts in an area of the law will get burned eventually if you rely too heavily upon it. And so there's a number of techniques you can use to compensate, like one, use multiple AI, at least 3, and compare the outputs. Compare the AI's outputs to your own Google searching or your own Westlaw Alexa searching. Talk to your colleagues. So you do need to offset it because you will get burned eventually. And when I'm using AI in an area where I have expertise, I will consistently find mistakes in errors, mistakes in fact, and mistakes in law. I will consistently find that. And so I have to assume that when I'm asking in areas where I'm not an expert, I just don't know where the mistakes are. And that's a deep concern. So sometimes I just ask myself, like, does it seem credible? For example, for today's podcast, I was asking the different AI tools for examples in the transactional law context of risks and problems. And so it talked about things that we haven't mentioned so far, but one of them was like the boilerplate language in the contract could be inaccurate. It could grab the wrong identification provision or put in the wrong NDA. And it gave me the names of law firms, and it gave me a year. And I said, that's weird. I don't recall any of that happening. Like, it gave me like these Fortune 50 Vault 100
Yeah.
law firms. I'm like, So I began Googling it and I couldn't find evidence. So then I asked different AIs, is there any evidence that this thing actually happened? And they couldn't find any evidence of it either. So sometimes you will get an instinct, but that's because I've looked at this AI stuff for a little bit and I can kind of feel like that seems implausible, right? The problem is how do you know what you don't know? There's known unknowns and there's unknown unknowns. How do you know when AI is gaslighting you? You don't always know.
Yeah, and I think that scares a lot of lawyers off from AI. I think thinking like, well, I have to go read the whole document anyway, or I have to go do this anyway because I can't trust it not to hallucinate. I think maybe spooks some lawyers from adopting it, but I very much so think that's not that's an overreaction. I think you can use these tools appropriately if you deploy some of the techniques you've mentioned. I will frequently, yeah.
Treat it as a complement or a supplement, not a substitute. Treat it as an assistant or an aid, not the primary, not the initial, not the core generator, but it's a complement, a supplement, an aid. Treat it as a conversational partner. Have a conversation with it. Ask it to challenge itself. So some basic techniques here is you feed one AI's output into another AI. You say, find all the problems, critique this, be skeptical. What's wrong with this document? And then you can kind of get a sense, the things it's picking out, I don't agree with, or I do agree with. And that gives you a sense for the reliability of the first document. But at this point, I'm kind of using the 3 AI technique. If 2 to 3 agree, maybe it's true. Again, a big caveat. I did a test this summer in August of 7 AIs. So I did Lexis's Protege, Westlaw's co-counsel, and then Grok, Claude, Perplexity, and ChatGPT, right? And then one more. And was it like, I'm coming in a moment here, but like 7 of these AIs. And I fed the same question. I said, hey, given that in February, the Trump administration said that they're going to repeal a Biden policy limiting the export of AI models, and B, given the July 2025 White House plan to remove all barriers to AI development, what is the likelihood that the Biden administration will actually remove this AI ban? And so what's interesting is the legal databases, and 2 of the 4 non-legal ones said it was unlikely, it won't happen, that it won't happen. I said, well, that's wrong. I'm pretty clear to me that they said they would do it. They haven't done it yet, but they're going to get to it by 2026. So the answer should be it's likely to happen. And so what's interesting is of the 7 AIs, 2 said it was likely to happen. 1 said it was irrelevant or defunct. And then 4 said it was not going to happen. So again, if you pick the 3 that said it wasn't going to happen, then you didn't. So again, it cannot substitute for human judgment, particularly in forecasting and trying to make predictions. And I could be wrong. Maybe the 4 that said it won't happen are right, but I'm pretty sure it's going to get repealed in 2026. And check back in a year, we'll see if I was right or not, or if the 4 to 7 AIs were right.
Yeah, no, I absolutely have had similar experiences jumping between the various models. I think the upshot of this for anyone listening who's a practitioner is try it out, use it in different contexts, but safely. Don't expect it to produce a fact for you. I also love a moment ago you mentioned how when you started asking it questions about your area of expertise, suddenly you realize the concerns with it. I have had that experience, and it has spooked me on, if it's making this mistake when I ask it about 83B elections, I'm sure it is doing this across the board when I'm asking about other things, and I need to be conscious of that. Again, though, and I because I'm so bullish on AI, I reiterate, that doesn't make these tools useless at all. There's amazing.
Well, when it's good, it's really good. So
totally.
I saw between 2022's version of ChatGPT and 2025's version a dramatic improvement in capability. And I'm looking at the current Grok version 5, GPT version 5. It's even when it's right, it's super right. So in my area of expertise, it's there. And I can see at this current trajectory in a year or 2, it may be beyond my current level of expertise, maybe better than I am when it's right. And so that's the real concern is if the AI can consistently and reliably be correct to the level of accuracy that we attorneys need, level of precision and accuracy, then we really will no longer in theory, need to do some of those basic research tasks and basic analysis tasks. We'll still need to think about future projections. We'll think about around, the AI can look at the past and try to make a linear projection to the future, but it can't form an opinion about the future or about where the law is going, what's likely to come down. It can't form that opinion in a way that we humans can yet. And so that's still an area where we're really critical here. But yeah, I mean, if this 50 to 80% hallucination rate is taken care of, and if the chain of reasoning that the CEO of NVIDIA is talking about really manifests in the next couple of years, we can see a dramatic improvement in the power of these tools. And then I'll be saying to partners, not only are your mid-levels at risk, but your entries are at risk, but your mid-level associates are at risk as well.
Yeah, and looking forward kind of at the profession, and as we come up on time a bit here, I want to ask you, and this, I've had this conversation with various folks who are bullish on AI or not, is a point going to come, is it already here perhaps, where it is your ethical responsibility to be using these tools as a lawyer? I think we agree there's an ethical responsibility to be competent if you are using them and to be careful about the way you use them. But are the efficiency gains or the value associated with these tools going to get to a point where you kind of have to use it if you're seriously practicing? Or where do you think we are on that?
I think that question is the same question as, is it legal malpractice not to research for currency of law in Westlaw and Lexis or a law library? And if the answer is yes, you need to check if it's still good law by doing shepherding or a Westlaw key site, then yeah, you need to use Gen AI tools as well. So I think the answer is eventually the answer is going to be yes, it will be considered negligence or malpractice not to use Gen AI tools. The issue is timing. I think in some areas of the law that are rapidly changing, it's probably technically malpractice right now. If your area of law is static and doesn't change very rapidly, then come back in a couple of years and it's still going to be required there as well. But I'm looking at things like cybersecurity, data privacy, artificial intelligence, national security, areas of copyright law, IP law, areas of the law that are dynamic and seeing lots of turnover. And there in the AI front, there's so much happening that even when I'm looking at Substacks, email listservs, periodicals from the law associations, YouTube videos, Twitter X feeds, I'm looking at everything. I'm getting less than 1% of what's happening. I'm seeing videos from inventors and entrepreneurs and tech giants that are throwing out terminology where I'm like, wow, like that's a whole area of knowledge I don't have time to get, and I'm thinking about AI. So I think it's going to be, in order for us humans to keep up to speed with changes in the world in general and in our areas of expertise, we're going to need the AI tools. And if you don't use them, you're going to miss things eventually. And that's going to be the problem for you, is that it can lead to both malpractice and to potential attorney discipline.
Yeah, no, and I'll say it's been remarkable how much I have been able to learn using AI. I have broadened my skill set across the board on things from, the law in certain ways to chess. I mean, there's so many opportunities out there with these tools. So I encourage everyone to, at a minimum, start asking about maybe your hobbies or things that you might be interested in, because it's very good at giving you kind of maybe a specific analysis of something that otherwise might be hard to find the answer to on your own. But I am keen on following the growth of AI and where that ethical line gets drawn onto our requirement that we use it as attorneys. But overall, I think we're trying to make it clear to folks, you need to review these outputs right now. It's a tool. Treat it like any other tool. It's not going to replace judgment. As we kind of get to the end of our time here, is there anything that you would want to make sure you convey to a practitioner kind of using AI maybe for the first time or using in their practice regularly? Is there anything specifically that you want to share with our audience on that point?
Number one, never put client details in the AI.
Agreed.
Never. Even if you have a license, I worry about that. If you have a bespoke application where you pay to have it customized just for your company, just for your law practice, then maybe, right? So think Clio. If you have the Clio level of contracting embedded guarantees, enforceable contractual arrangements, then maybe, but otherwise never put client data into these tools. It is, in my personal view, per se negligence. It's done, right? Number two, whatever comes out, you must have a human evaluate it. You trust but verify. Trust but verify. You must check it all. It's your bar license on the line. You got to check every word, every factual claim, every legal claim. You got to go back and re-verify the cases exist, because the AI is really good at BSing. It's really good at thinking like the cases are real and they sound like they're real, right? You got to think about when you are writing a contract, reviewing a contract, writing a brief, ask the AI for both pro and con. What are the strengths? What are the weaknesses? Ask multiple AIs. Have them critique each other. So these retrieval automatic generators, these tools are known to be sycophants. They want to please us. They want to be biased to get our emotional engagement. So that's a big issue here is thinking about making certain that we protect ourselves legally from both malpractice as well as discipline actions here. And I would say that you should begin thinking right now about governance. So how do you handle data in general? How do you deal with your client's data? How are you ensuring that lawyers aren't just going on their home computers or their smartphones and then typing in these queries? So you may have an AI use policy that bans the use of Gen AI tools. You can't use these tools, but then they just go home and use them, right? So you maybe have an amnesty. You say, hey, we're not going to hold anybody guilty. We just need to know what the deal here is. We got to have a way of structuring the use of these tools and get it out. I think those are the main ideas here. We can dig into, I have like 100 points for practitioners, but those are probably the big four for our conversation right now.
Yeah, I think that's a great kind of summary, get up to speed on how to get going with AI as a lawyer. You got to be mindful of those things. And I also am very thoughtful about what you say, how are they actually, there might be a firm policy, but how are folks actually using these? It is extremely easy to accidentally copy and paste client information. And if you're grabbing one clause that you don't think has confidential information in it, those errors are going to happen across a firm or across any large group of lawyers. Policing that or training your employees or your fellow practitioners to not make those errors or to at least be mindful of them, I think is a big part of this. And it's also part of the reason why I'm so encouraging of folks learning AI and how to use it and being comfortable with it. So it's not this scary thing that they're going to be more likely to make errors with when using it. But this has been a fascinating conversation. I really appreciate your time on all of this. I think we've surfaced a lot of kind of the stakes here. There's a huge upside. There's clear risks. We're not talking about bugs. This is just how these systems work. And we as lawyers need to learn how to kind of use those systems because of the value that they can produce long-term. And we cannot be replacing professional judgment. I love earlier in the conversation, you're saying this is our guild. We as lawyers have a responsibility to kind of work together and hopefully create a system that is more efficient and better for everybody with these tools, but without letting those tools kind of dictate where the profession goes. So for listeners who want to learn more, we'll link to Professor Haynes' work and our latest white paper on hallucinations, omissions, and bias in the show notes. And don't forget to subscribe to AI Practice Notes for more information and more conversations with thinkers like the professor here and other builders who are shaping the future of legal work. So thank you very much, Professor. Really appreciate your time.
Thank you so much, Michael. Thank you for inviting me.